All right, hello everyone, and welcome to our fourth episode this season of Space Law webinars at the Law, Technology, and Warfare Research Cell at the U.S. Air Force Academy. I'm Major Matt Ormsbee, and I'm pleased to bring you another webinar on space law and policy today. For our fourth webinar of the season, we're very excited today to welcome Dr. Gershon Hasin. Dr. Hasin is an international legal scholar and practitioner. He's currently a member of Fietta LLP in London, and has previously taught law of the sea and law of outer space at Yale Law School, where he also earned his JSD in 2021. His research and publications focus primarily on the regulation of common resources under international law. He's published in leading international law journals, including the Yale Journal of International Law and the Harvard International Law Journal. And in addition to scholarship and teaching, he has extensive experience in international litigation and arbitration, including before the International Court of Justice. Dr. Hasin, thank you so much for being with us today. At this time, I'll turn it over to you and let you begin your presentation. Over to you. Thank you.
Great. Thank you, Professor Ormsbee, for inviting me to speak, and I'd like to thank the U.S. Air Force Academy. I'm sorry, I have to apologize. I'm a little, I might not be my best. I'm a little shaken up. I just caught up on the news from my home country of Israel and saw that a 10-month baby was killed in captivity. So I apologize if I'm a little off my game, so to speak. So in the recent decade, we've seen a lot of a boom, a development in space activity, both public and private. And so it's important, I think, to take this time to talk about how we approach the development of law in outer space, and not in the sense of what the law should be. That's an interesting exercise, but how we think about the development of law in outer space. How do we approach it from a perspective that integrates a theoretical and a practical approach? So one such way of perspective on activities in space is called policy, kind of what I call the space governance approach based on policy-oriented jurisprudence. And I'm gonna spend time to talk about it right now. So I came to the subject of space law, in a sense, as I guess many of you as well, from well-established fields of international law. My kind of fields were law of the sea and international investment law, and I assume for many of you, it will be the laws of war. So my own perspective on regulation of space activities are really shaped by the actual development and application of international law. Now, there are different ways of looking at international law, and I think we can broadly kind of categorize them into three separate approaches. We have a normative or moral analysis of what should be. We have a legalistic and positivist analysis of, let's say, what the law is. And we have a social legal analysis, or what's called legal realism, which looks at international law as a process. Policy-oriented jurisprudence is one such approach, a social legal approach to international law. Now, when I came into the field of space law, I was a little bit kind of surprised to see the scholarship was mainly engaged in kind of these internal discussions in between themselves, which sort of leads to amplification of certain perspective or certain rules more than what other people coming from other disciplines of international law would give them. In quite a surprising realization was that most scholarship basically followed the first and second approaches, basically normatively saying what it should be and also amplifying what the law is and how we apply it. rather than, for example, thinking of law as a process of development. So in this kind of talk, I'll explain a little bit about my approach based on, like I said, policy-oriented jurisprudence, or what's called the New Haven School of International Law. And if I have time, illustrate it a little bit on anti-satellite weapons and space debris, which are current issues, very interesting to think about. Now, in legal practice, we have laws, precedents, commentaries, and we normally approach law from a positivist or legalistic perspective. So when we consider a problem, a certain problem, a case, a legal question, we tend to view all law as authoritative and basically engage in interpretation and application. Now, for a policymaker, law is somewhat different. It's more dynamic and can be viewed as enabling, restraining, supporting, or outright prohibiting a proposed policy. Now, when lawyers approach international law, we have a tendency of treating all existing law as authoritative, and then considering how this law should be applied to deal with a specific problem facing us. In contrast to that, lawyers, in contrast to we policymakers, have a tendency of treating incidents when a rule is purportedly breached judgmentally, rather than focusing on how other participants respond and perceive such events. In policy-oriented jurisprudence, we would treat international law as a set of arrangements intended to shape policy choices of participants towards what we call the common interest. So we focus on the process of interactions between participants, considering their correlating and conflicting goals, interests, and points of leverage, to try and understand what the probable outcomes of interactions are going to be, and how do we shape the decisions of actors towards our preferred outcomes, which, as I mentioned, promote the common interest, which basically refers to, one, the minimum order, which talks about preventing conflict, and the optimum order, which is defined as the aggregated gain and international values by participants. The values I looked at were, and I think are correct at this point in time, would be wealth, innovation, safety, security, environmental protection, human dignity, and in certain aspects, prestige. But values are dynamic, and they develop as interactions and circumstances evolve. Now, when it comes to considering the lawfulness of certain decisions under international law, we would distinguish between two separate modes of decision. The first is called a textual rule-based mode of decision, when the question basically asks is what rule applies. The rule is interpreted and applied, leading to certain claims of illegality, proposed policies, or even suggested arrangements. Now, this mode of decision is founded primarily on domestic law, where there is a high or even certain probability that we're going to encounter a legal decision maker. That could be a court, a tribunal, or whatever. And this leads us to treat the specific rule as authoritative and one which is controlling the decisions of actors. In certain aspects, we may even assume that the rule is enduring and must lay at the foundation of any proposed regime. Now, such what's called rule crunching, so to speak, in international law can be quite problematic, because with the exception of certain what we would call legal enclaves, such as, for example, the law of the sea or international investment law, the majority of international arrangements do not provide for a court or a tribunal to review the decision on legality. Now, this is even more true when we think about space governance, where the norms are outdated, they're vague, they can be easily denounced, they lack any meaningful enforcement mechanisms except reciprocity. So in such offshore zones of international law, so to speak, a contextual policy-based mode of decision is more appropriate. This mode of decision focuses, as I said, on the participants involved, their interests, goals, points of leverage, bases of power, interactions, and outcomes. So the focus here is on the goal values of the international community, which arrangements can effectively produce and distribute the values. How can those arrangements be installed? So while rules or norms, so to speak, are to be considered, they shouldn't be considered grammatically, but rather in their ability to shape the decisions of actors towards desired outcomes. Now, in this mode of decision, when a rule is purportedly breached, it's far more interesting to think about how other participants react to the act and how it will shape the development of international law rather than whether a specific norm has been breached. This kind of thought process can indicate whether this norm will be enforced, disregarded, modified through interpretation, or maybe even abandoned as obsolete. Now, so from this kind of descriptive perspective, policy-oriented jurisprudence tries to understand a specific instrument and how it shapes the decisions of states towards the common interest, while from a prescriptive perspective, when we think about how law should be shaped, it's not the best governance, but we would say the best plausible governance in light of existing and anticipated interactions. In my scholarship, I distinguish between kind of three different elements. I call them feasibility, effectiveness, and manageability. In most basic terms, feasibility refers to whether a proposed governance regime is likely to be adopted by the participants in light of their correlating and conflicting goals, interests, and points of leverage. Effectiveness considers whether the kind of proposed regime optimizes gains and values for participants. And the final element, manageability, looks at whether kind of this arrangement is able to sway the policy choices of what would be kind of reluctant participants or outliers to promote effectiveness. So by looking at these kind of three elements, we can identify whether an existing regime is no longer effective and manageable and needs to evolve to one which is. But thinking through that process of evolution, we need to remember that it has to be feasible and correspond to the interests of the participants involved. Now, going from kind of the general to the more specific, like I said, when I began looking at space activities, I encountered two major themes in scholarship. One was basically rule crunching, and the other was what I called regime transplantation. And I think that looking at the circumstances that we have today, those approaches are wrong. They're not appropriate. Now, I'll start with kind of explaining what I mean by rule crunching. Any specific approaches where a specific rule, it's usually a principle of the 1967 treaty, commonly referred to as the Outer Space Treaty. The principle is interpreted and applied, producing certain policy suggestions, claims of illegality, or claims even of governance. It assumes that not only is this treaty authoritative, but because this treaty is very broadly worded, that it is the interpretation of the specific author that is authoritative, and that it affects the policy choices of participants. I think also that such an approach limits our ability to think about the possible when we think about the development of the law, because it grounds us in the existing norms, sort of presumption of endurance with respect to those rules or norms, irrespective of the changing circumstances. Now, a well-known example of this comes from the discussions on space resources. A lot of ink has been spilled on arguing that Article 2 of the 1967 treaty should be interpreted to either allow or preclude resource extraction. Others called it, said it was customary norm, and others even called it a peremptory norm. Now, from a New Haven, a policy-oriented perspective, the more important question is how this change in circumstances, and talking the possibility of resource extraction, is going to shape and be shaped by international law, not whether we can interpret a 1967 norm to apply. So in fact, if we look at the Artemis Accords, they kind of show how this rule can be adopted or should be adopted to modern interactions. A second theme, as I mentioned, was regime transplantation. Now, basically the concept, the approach is we look at a certain problem in space, and now we look at an existing regime, and we're going to apply that regime with some changes to govern the activity in space. And again, the most kind of well-known and common analogy was, again, to the law of the sea. And it concerned the regulation of resources, and particularly what's called the international area, what's governed by the International Seabed Authority, known as the common heritage of mankind. Now, for someone coming from the law of the sea, I found that analogy, that approach kind of a little bit puzzling. First of all, because the law of the sea is clearly illustrates that international law evolves with the changing circumstances and not remain static. So or we don't take norms that applied in let's say the 19th century and interpret using those norms the legality of let's say seabed or the continental shelf, right? Things change and the law adapts. But specifically for that analogy, it disregards the fact that the international area under the law of the sea is the seabed and subsoil beyond national jurisdiction. Now, that national jurisdiction under the law of the sea convention extends to beyond 200 nautical miles and even beyond that distance. But the major point is that the formulation of the convention assigned the vast majority of valuable and commercially valuable and accessible natural resources of the seabed and the subsoil, mainly oil and gas, exclusively to the coastal states, leaving for the common heritage the least accessible and I think even today not yet commercially viable resources. So the approach, I was looking into space and seeing what authors perceived to be a common area, then looking down the earth, saying, oh, here's how a common area is regulated. Aha, let's apply that. But I think that, like I said, disregards the situations that gave rise to this specific regime. It disregards the fact that international regimes are a product of interactions by certain participants in certain circumstances at a certain point in time. And they can't simply be applied. And if we look at that example of the area, the question that really bugged me was like, why would they agree? Why would anyone agree to take this regime intended to govern the least accessible resources and apply it to all of space? Now, a contextual approach, in contrast, would look at international governance of space activities as problem solvers, looking at the participants, their interactions, optimization of values. So the participants can be if we look at them, they're basically the space-capable states that don't have or are developing those capabilities, international organizations, and private entities. Now, as space activities mature, these participants can change as well as the relative leverage that they may exert. Now, recognizing that the regulation of space is going to be kind of shaped through their interactions, proposing arrangements which are detached from their interests and leverages and anticipated interactions is really not feasible. And so in a recent publication, I proposed 6 analytical components. It's not a mechanical analysis, but kind of things to look at when we're looking at space, at the development of space governance through a policy-oriented perspective. First is to try and delineate the public policy that we're trying to tackle and try and understand how it works under existing kind of norms. We then identify the certain participants involved in interactions, define the international values, and understand how they kind of interrelate with the problem we're looking at. Placing the problem within the kind of the complex global order, right? We have to understand that there are direct but also indirect rules of international law that shape the decisions of actors. It's not only these space treaties, it can be international investment law, environmental law, and so forth. We can then consider the interactions between the various participants and trying to ascertain the outcomes. But this is a circular process because those outcomes are going to be the new circumstances that are going to produce additional interactions. Now, before kind of turning to the specific examples I wanted to talk about, I'd like to kind of spend a few minutes kind of emphasizing the different process that we see today. So, in contrast to the more formal lawmaking process of the 1960s and 70s, the approach today, you can see that in the Artemis Accords, is to create a framework in which interactions can occur. And through those interactions in practice, the law will be shaped. Now, this is, I would argue, a sensible path. Well, we don't really know what we don't know. And so setting certain rules before we know the specific externality or problem that we have to deal with, that's like putting the cart before the horse. Now, for example, if we look at the Artemis Accords, we can see an evolutionary approach with the safety zones, for example, right? That they're going to develop as and evolve as needed. And such international kind of lawmaking process allows for the integration in some way of private entities, which are going to be important players in the space arena, and we're already seeing that today. An interesting example on this, and I might be, this is someone told me, I might be wrong in the science even, but as I understand it, when starting to think about the lunar missions, I figured out that because they need access to solar power, when moving between certain installations, they're going to have to, there's going to be, because of the topography, there's going to be certain paths that are going to have to be followed between these installations. Now, that is a realization, right? What can we do with them, right? If we would have set a norm without knowing that, that would have been wrong, right? It wouldn't be consistent with the realities. But also, does it make sense to try and take a 1967 principle, interpret it, and then make certain claims of legality or illegality concerning certain needs, right, to control these paths? I would argue that it doesn't. Now, like I said, I want to talk a little bit about kind of how to, not mechanically again, but how to explain how this approach that I talked about would look at two issues, space debris and anti-satellite weapons, even somehow interconnected, right? So space debris, I mean, we'll know it, it's an externality of space activities. It can be small pieces of metal or big disposed satellites or boosters. And it increases the risks and costs for space activities by others. And so when we think about the kind of the development of international law to govern space activities, in that sense of debris, we need to first appreciate that the public policy problem we're dealing with is not reducing space debris per se, but rather promoting space activities by enabling safe and effective space traffic management. Right? The mitigation of debris is the instrument. Right? It's not the goal of the arrangement. So when we think about debris mitigation, we need to account for several issues. First of all, adaptation capabilities. Right? The more we're able to protect space assets, the less we need to invest in mitigation. We also, with that in mind, need to kind of appreciate that we need to reduce debris to a point of what would be economic efficiency, right? Where any further costs of further reductions basically outweigh the cost of adaptation or loss. Now, as technology develops, we may even be able to remove some of that debris, or we might reach a point where we inspire to internalize all the negative externalities, kind of an analogy to the end of externalities approach for environmental law, but we're far, far away from that point. Now, as I mentioned, policy-oriented jurisprudence would evaluate and place the specific problem within the context of interactions. So think about, for example, the states that are currently developing capabilities, right? For them, debris proliferation is a hindrance. But on the other hand, increasing costs of mitigation is going to harm the development of activities and the benefits they produce. For advanced participants who are now developing private industries, right, increased adaptation capabilities allow for less investment in mitigation. And when you're increasing the costs of certain ventures, you're risking, on the one hand, reducing innovation, which we don't want to do, but we're also risking a situation where we encourage participants to relocate to other more lenient, so to speak, jurisdictions, which risks instigating what has been called in the kind of environmental context a regulatory race to the bottom. Now, with the development of I want to explain that for a second, right? With the development of private space activities, states that do not have space capabilities are in fact incentivized to attract investors. Now, that are going to kind of develop space activities, but the primary ways to do that, if we think especially of activities which are primarily or solely in space, is by domestic laws and regulations, right? It's not like we have oil, come get the oil, right? So such rules can increase the gains of investors. That's how you basically attract them through on the kind of the perhaps the best scenario would be increasing their property rights, or the worst scenario, which is basically reduced environmental and sustainability commitments. Now, in a previous kind of publication, I dealt with the example of lenient obligations to mitigate space debris. But there are other problems that we can think about, such as worker protection, intellectual property, issues concerning contamination or even emissions. In environmental context, these were called pollution havens. So in effect, while the specific country or jurisdiction has it prefers an immediate gain in wealth on account of future sustainability, while the negative externalities produced by the activity, in our example, debris, spread and affect all other participants as well. And this risks kind of turning into a circular process. Now, under international law, it's quite difficult to arrest this process because we can't set, it's very difficult to set norms that apply throughout all jurisdictions because international law, as you know, is based on state consent. The other way we can think about, and I think is worth thinking about, is increasing the costs of relocation for actors. And unfortunately, we have seen some of this process already happening. Now, and I'll talk a little bit more about that later, but we should also keep in mind that debris, right, has been produced by testing of anti-satellite weapons. The Chinese test created a lot of debris, and we've seen subsequent tests as well, recently by Russia and before that by India. The United States has recently proclaimed a self-ban on the testing of destructive weapons and has promoted a resolution in the General Assembly of the United Nations calling for prohibition on testing. But I mean, as you may recall, China and Russia objected and India abstained. Now, but I'll get back to that later. But when we look at the interactions between the actors, the situation is interesting because, in effect, the major powers have already tested these weapons, and so they're primarily adversely affected by continuing testing and proliferation by others, which is an interesting kind of resemblance to situations, for example, with nuclear weapons, and we have non-proliferation and a testing ban. Now, it's important in this context, however, to keep in mind that the technological requirements and practical requirements for such weapons are much more or less difficult, so to speak, than when we would think about nuclear, chemical, or biological. Now, this in fact indicates for us that we need to take account of the interests of other actors involved rather than only looking at the major powers in this sense. Now, from a policy perspective, debris can be reasonably characterized as what's been called a wicked or even super wicked problem, which effectively defies solution because we have conflicting interests, we have some uncertainties about the future effects of this externality, we have an uneven distribution of costs, benefits, and in fact responsibility between different participants. We have no ability to define an end for the problem, and any norm that we adopt now is going to have kind of long-term effects, even perhaps path dependency, and unfortunately we also have some discounting of long-term effects of these undefined risks by decision makers. Now, the problem we have, right, as I said, that state actors on different levels of development can actually produce this externality, for example, by attracting investors. So it's important to recognize that the effectiveness of any mitigation regime here would depend on universality. Now, and what I mean by that is shaping the choices, the policy choices of as many, if not all, participants involved. Now, a normative perspective would look at this and say, well, good, so, let's have an international rule that applies to everyone and requires them to do X, Y, Z, which is kind of a top-down approach. Policy-oriented jurisprudence would begin by asking why would they agree, and a simple kind of the automatic answer to that would be, well, that's the right thing to do. But I think that disregards in many ways the process of international lawmaking and applying, which is based, as I said, on state consent. So X, Y, and Z in this case have to be feasible and based on the interactions between different actors. Now, sometimes, in fact, the proposed policy is not going to be the best. If we were only concerned with mitigating the externality, it will be, the most feasible one. And many international arrangements are in fact such package deals rather than what would be perfect solutions to a specific problem. So rather than looking at this in the abstract, we would approach the development of the governance from the kind of the bottom up. Now, one example, right? Many scholars have proposed economic instruments to shape decisions concerning space debris, like fees or taxes. And I'm talking about international level, not domestic level. We have domestic level that is separate. Now, domestically speaking, economic instruments are widely used to shape the decisions of actors. But such approach is basically based on the realization that the consent of each individual actor to be bound by the arrangement is not a prerequisite, right? If you go to a gas station, you can't pull out a card and say, "Oh, I'm excusing myself from the tax." That would make no sense, right? But in international law, that kind of works that way. So for economic measures to be effective here, they would have to basically apply across the board. So they're going to have to be accepted, complied, and enforced on virtually all relevant actors. And so an outlier not subject to the rule, especially if they're able to attract foreign investors, is going to undermine the effectiveness and manageability of such norms. I don't want to go too much into it, but kind of in my suggestion, the experience kind of indicates, especially when we're looking at climate change, that a consensus between kind of multiple participants facing such a wicked problem is best achieved through incremental steps, discretion, cooperation, enforced through transparency or shaming rather than top-down command and control. Basically by producing a reduction in by reducing the effects on state interests, we're able to generate more participation. Now, is that leads to a perfect? No, it's not perfect, but at least we're able to promote our public policy goal. And we've seen that in such situations, sometimes imposing strict norms can be counterproductive. Now, another kind of interesting point in that sense is that recognizing what I said about kind of the regulatory race to the bottom, it's important to appreciate that perhaps we have to rethink about our international investment protection system. In addition to the reasons that everyone's talking about, also from this perspective of space, of whether or not we really want to kind of, it's going a little bit beyond what I was planning to talk about, but we want to encourage investment in space, not necessarily foreign investment in space, right? So we have to think about it, right? The United States, for example, wants to develop a domestic industry, not export it. So we have to think about whether the rules or norms of foreign investment protection are relevant and are promoting our goal values, rather than undermining them by, for example, protecting these kind of relocations to less strict jurisdictions. So the other point about when we think about this is that I think that space gives us an opportunity to really incorporate what would be the private polluters, so to speak, into the governance regime itself. Something that was missed in climate change and has been criticized for that. But I do think that here, especially because of the centrality of private actors, we have an opportunity to correct that and really integrate them into the governance. Will be a true bottom-up governance. So I'll turn briefly now to anti-satellite weapons, which, as I indicated, is something very, it relates to debris. I'm sure many of you know the anti-satellite weapons better than me, but but I'll try to give my contribution to the discussion. So, there are different types of ASAT weapons. Some target satellites through kinetic means, or others by non-kinetic means. Some destroy satellites, others commandeer them, blind them, disable them. Some are in space, others are ground-based. Yet, in reality, the proliferation of all space weapons places at risk the financial interests and security interests of many different actors. Critically, when the testing of or use, in reality, of such weapon creates debris or even increases the chances of creating a debris, like disable a satellite, the risk and costs to many different actors involved in space activities increase as well. Now, as I mentioned, there was a push in the United Nations towards a kind of a ban of destructive testing. But unfortunately not on proliferation. I think it's an indirect way of limiting proliferation. If you limit testing, you limit proliferation. But so while in the United Nations you had overwhelming support, where it comes to the international lawmaking process, and we're again talking about the participants involved, it's important to appreciate who the objectors were. And in this case, we had Russia and China, who objected, and India abstained. All of them previously conducted anti-satellite weapons. Now, it is reported, and again, that's basically what we have. We don't know exactly what goes on in those decision-making realms. But for China and Russia, it's been said that the prohibition on testing for them should be kind of accompanied by a prohibition on the placement of weapons in space, a proposition they have been advocating for some time. The United States has objected to that for different reasons, but there is in fact some merit to the issue linkage. Otherwise, states would be able to place weapons in orbit while others would be limited in their ability to develop countermeasures. The formal lawmaking process here seems to be really dependent on a compromise that neither side is really willing to make. Russia and China are not eager to relinquish their possibility of developing ASAT weapons as they say, as a response to possible placement of weapons in orbit, while the United States is not keen on relinquishing its right to develop and place weapons in orbit, a capability which it will likely lead in, and has also rightfully pointed out problems in verification of compliance with definitions and verification of compliance. So now a call in the General Assembly could be an important step, but it is declaratory in nature. And if we consider who objected and who abstained, it kind of indicates to us that the resolution has a limited ability to really affect the policy choices of outliers when it comes to the testing of anti-satellite weapons. And not to mention even their proliferation, which is problematic on its own. In these circumstances, I think it's important to consider other avenues by which interested participants or interested stakeholders, for this matter, to shape the decisions of states where it comes to arresting, testing, and the proliferation of ASATs. In this sense, it's important to appreciate that the participants include not only states and international organizations, but also private entities. And I think it's a unique and interesting situation where even a conflict between two very remote actors, may not be even significant or major actors, can be devastating on the economy of others. Right? I mean, you destroy satellites in space, you create debris that can destroy other satellites, and so cripple our economy, which is basically based on, in large part, on satellites and space activities. So, and in addition to that, when we think about state actors and state participants, it's important to appreciate that the participants here go and extend beyond what would be the major space powers and include other states with that are developing these capabilities, which are less extensive, let's say, than what is required to launch missions. In a forthcoming publication, I suggested that the observed and anticipated interactions between the various kind of actors involved indicate 5 possible paths through which we can control the decisions of actors where it comes to the proliferation and testing of ASATs. Those are not perfect or bulletproof solutions, obviously, just tended to begin a conversation. The first is a limited, confined action through Security Council for a narrow compromise to overcome what is a collective action problem. The use of informal clubs of states to employ certain trade measures. The third, which I'll talk about a little bit more, is to employ the space programs as a sort of a carrot and stick instrument. The fourth, implement economic measures by certain private entities to shape state behavior. And the final is to promote what called Transcommons impact assessment as a mechanism of transparency and accountability. Now, I want to focus on that third element, the use of the space programs, because I think it's interesting and, in fact, perhaps even doable. So in contrast, like I mentioned, right, in contrast to the lawmaking process of the 20th century, we see a divergence here. Right? The United States, on the one hand, is promoting the Artemis program. China, with the participation of Russia, has put forth its own competing framework program for space activities. And so it's becoming clear that the path the approach that these states are taking, in this sense, is kind of a take it or leave it, or take it or be left behind. Sorry. So, right, countries are basically sort of, and especially when we're talking about developing countries, are encouraged to join either of these space programs, agreeing to certain underlying norms, or risk being left behind in what is obviously a new space age. The point here is that the space powers have the ability to promote their preferred kind of international norms de facto through participation or conditioning the participation in the space programs. Now, we've seen this in the Artemis Accords with the examples, very known examples of the interpretation concerning space resources and also the safety zones. So, the fact that the major powers have an interest, in fact, to limit the proliferation and development of space of anti-satellite weapons, we can think about the use of these programs to promote such norms. China and Russia may not agree to an overall ban on testing, absent a commitment by the United States and others to refrain from placing weapons in orbit. But that doesn't mean that they don't have an interest to limit destructive testing and the proliferation of these weapons. Now, a possible path, for example, is, and the United States has avoided this so far, is to condition, for example, participation in the program or certain measures to limit proliferation or completely kind of refrain from testing anti-satellite weapons. China may in fact decide to follow suit and require state participating in its own program to do the same. Now, given that this path will not, legally speaking, preclude China and Russia from executing such tests if they believe that the threat from placement of weapons in orbit justifies that, the cost, so to speak, of this arrangement would be much more minimal for them. But the incentives to participate in a program, any program, or be left behind will really kind of ensure, or could ensure, that as states continue to develop their space capabilities, ASAT testing and proliferation is reduced. Such interactions may in fact show a path through which a new package deal, so to speak, can be reached between the United States and China on this. But even without that, any, so to speak, reduction in the proliferation and testing will promote the public policy goal of supporting a sustainable space environment. So I'll stop here, and I thank you all for listening. I'm happy to take questions now. Professor Ormsbee has my email. I'm also happy to answer any additional questions. Okay.
Thank you so much, Dr. Hasin. We appreciate your research presentation and all your thoughts on this topic. You raised many interesting points about law and policy. And so I know at this point, we'll turn to questions from participants. And by all means, if anyone has questions that you've been sitting on, you can please put them in the Q&A box, and we'll pose those questions to Dr. Hasin, time permitting. One of the questions that we had is, how can we mix general norms of international law with special rules in order to open up the development, for example, of debris recycling or mining in future space law frameworks?
Mm-hmm. I think it's a really interesting question, and I think it fits into the kind of 2 points. First of all, is a realization that space is not like the regulation of space is not separate from other fields of international law. And so international law, general public international law, would still apply in space. And so when I mentioned, for example, thinking of fitting the problem we're dealing with, for example, sustainability in what would be space resource missions, within the kind of the complex global order, what I was referring to, in a sense of thinking about how other norms are going to affect those decisions. One example, if we look at international environmental law, is what have been kind of the environmental impact assessments. And we've seen these measures develop, right? Recently, the BB&J, the Biodiversity Beyond National Jurisdiction Treaty, was adopted. It's not yet enforced, but it has its own kind of environmental impact assessment that is more defined and developed than what would be a general impact assessment under international law. So that is kind of one way when we can kind of think about how to take these arrangements, these rules, how they will apply in space, but not take them and apply them, because they're not necessarily going to be exactly consistent with the circumstances. But we should appreciate that they will apply and will shape decisions in certain ways, for good and bad, right? Investment protection can do that for the worse. Environmental protection can do that for the best. And so it's an important question that we'll have to further think about and deal with.
Thank you. The next question, it's somewhat broad, so you can take it any direction you like. It's generally asking how the conflict between Russia, China, and the US will affect outer space activities. So I'll let you take that any direction you think is appropriate.
Sure, I'm happy to tell. I think that's a really, really important point. And when we look into I kind of hinted to that when I said divergence. What we're seeing right now is that the United States is going with one space program, the Artemis Accords. It has certain norms under it, and it's going to develop those norms. They're evolutionary in nature. It's going to probably add certain additional norms as they go along. But China and Russia are going with their own space program. We don't know exactly the details, obviously. They're not as open and readily available. But what we're likely going to see, in some sense, is a divergence of norms because, well, space is big. And as long as there are no interactions between those two space programs, there's not going to be need for settling on certain arrangements. But as activities develop, there might be some divergence, but if we're going to start seeing conflicts between them, it can be on lunar missions, for example, then we're going to see some convergence on certain norms. Now, for example, as I mentioned, the paths that we're likely going to have on the moon to move between different infrastructure, different facilities. Right? That will necessarily generate some conflict. And once that does generate conflict, then we're going to start seeing the development of norms. But the risk is, and it's a genuine risk, that, we're talking about norms such as resources, general norms, but there are other norms that we have to think about, like worker protection, human rights, private property, a lot of different norms that are going to apply as activities develop, and we will probably see some divergence there, and we'll have to see how that develops. But it's a really kind of important point to keep in our minds as we think about the development of law in outer space, to also keep in mind that we shouldn't necessarily talk about one law developing. But we should also appreciate that in some aspects, we're going to have a divergence between these norms, because there's going to be practice happening under the Artemis program, and there's going to be practice happening under the Chinese program, and it's not necessarily going to go in the same way.
Thank you. Looking at the time, this will probably be our last question of the day. Do you think that the legal qualification of space resources as res communis omnium, or global commons, is crucial in the academic debate?
I think that in the academic debate, looking at space resources and trying to define them under certain norms or rules that govern, or principles, communities that govern interactions in the Earth has a very limited lifespan. These are different situations. It's not situations we've encountered. These are not fish. This is not, we can't think about kind of the law of the sea, right? The extension of the seabed and subsoil, but that was tied to sovereignty over land. We don't even know if, and we probably can anticipate that at some point there's going to be something similar to terrestrial sovereignty that's going to be required, or the territorial sea, certain security measures. And we see that in the safety zones as a kind of a premonition. So thinking of these, I don't think it's essential to think about them that way, but I think it's essential to appreciate that these are different circumstances, and we can't necessarily take concepts that worked on the Earth, for better or for worse, and just try and apply them. Rather, we need to look at these as different situations, think about the various actors, think about the stages of development based on these kind of different interactions when we're thinking about space resources. I think and I have maybe 1 minute, but I'm not, to kind of continue on that point, I think the contrary perspective is the more troubling one, where we're trying to limit or try and use concepts and try to interpret a 1967 treaty or other, to say we're precluding these, the acquisition of resources. I think that doesn't work, because it is a completely different situation, and we shouldn't be taking these norms that were developed for certain situations in certain point of time and try and apply them to something completely different. So I hope I answered your questions, but again, I'm happy to take additional questions via email.
Thank you so much. I see that we're basically at the top of the hour. I want to respect your time and everyone else's time and call it good at the top of the hour. So I think we'll wrap up at this time. I want to sincerely thank you, Dr. Hasin, for your time, for your research presentation, your original thoughts today. Clearly, it's very thought-provoking. We have other questions. I apologize to everyone that we don't have time to get to all the questions that we have. I want to thank everyone in the audience in attendance today, and we'll have several more exciting speakers lined up for later in this academic year. So please keep tuning in to our space law webinar. And I want to say thank you again, Dr. Hasin, and have a great day, everyone.
Thank you. Thank you as well.